I'll start over. Good afternoon, everyone. Welcome to Liverpool Advocates and Windrush Q&A session. The first and the only one moving forward once a month for, in this case, October. Today's session, we will be looking at the Windrush compensation scheme, if there are any updates, what those updates are, and if anyone is interested, what is required or what they'll need to take into consideration to make a successful, not necessarily successful, but an application. I should correct myself. Joining us today is my co-chair and co-founder, Mr. Garrick Priok. Garrick, good afternoon. If at any point you have any questions, queries, please feel free to ask. One thing I will say is that I do not have all the answers, and we rely on each other to learn. We do learn from each other. One of the things I have noticed recently, and I've been wondering, was the categories of routes to claim, and if you arrived before the 31st of December 1972 from the Commonwealth, then you are a Windrush generation. You're considered as a Windrush generation. But the scheme goes to 31st of December 1988, and you're still considered a descendant or part of the Windrush generation. Just two distinctions to look into a bit more clearly. But nonetheless, I'm looking at specifically the caseworker guidance because I think that's more informative and clearer than looking at the applicant's guidance if they were to make an application, be it primary, secondary, or deceased. And for the benefit of everyone on the call, I'll put it in the chat, the link. So it'll be easy. And this is the latest version, which is updated in July. 9th of July 2024.
Yeah, 17 point something zero, isn't it? The number?
Yes, version 17.0.
Yeah.
Yeah, this is the latest version. Also, with regards to updates, I found a comprehensive guide as to all the updates that has taken place from 2019. So it was first published the 23rd of August 2019, the Windrush Compensation Scheme. Then it was updated the 30th of October 2019. The update then was updated guidance for primary claimants, close family members, and estate representatives. On the 5th of March 2020, the scheme was updated. Again, it updated primary claimant and deceased estate guidance. The 9th of October 2020, updates again. These were updated forms and guidance. On the 16th of December 2020, the updates were uploaded, revised documents. On the 21st of July 2021, the government replaced the primary claimant, Windrush compensation claim, guidance, and form. Gareth, I'll put a link in the chat. I see you writing, and instead of you doing...
Yeah, I'm just making a reference here.
I've just placed a link, and it's at the very bottom of said link that all of this information is.
Yeah.
On the 2nd of August 2021, the update was added guidance on the support available to make a claim as a representative of an estate and guidance on making an application if you are overseas. On the 27th of October 2021, the Home Office added guidance on requesting that a claim be considered out of order, updated the primary claim form and the guidance documents for primary claimant, close family member, and representative of an estate. On the 24th of August 2022, the Home Office updated guidance on claims by primary claimant, close family members, representative of an estate. August of 22nd of August of 2022, the form and guidance updated for primary claimant, close family member, and deceased estates to reflect changes to the scheme. Again, on the 22nd of August 2022, PDF versions of guidance added for primary claimant, close family member, and representative of an estate. On the 10th of November 2022, close family member claim form updated. The 16th of March 2023, update made to representative of an estate, Windrush compensation claim guidance, close family member, the Windrush compensation claim guidance, and the primary claimant, the Windrush compensation claim guidance. On the 23rd of June 2023, information on considering a claim out of order updated again. 24th of October 2023, changes to the eligibility criteria and updated company name for We Are Group, which is the organization that the Home Office has commissioned to assist potential claimants or claimants to the schemes. On the 18th of December 2023, the Home Office added information on what you need to do if you fill in the form on a computer. The 23rd of April 2024, primary claimant and close family member guidance and form have been updated to clarify medical evidence in support of a claim. Representative of an estate guidance and form have been updated with details of where to find information about the support available. 16th of May 2024, correction to the dates in the close family member guidance. Section 1, option F. This means the latest date they were in the UK was 31st of December 1972, not 31st of December 1973. And lastly, 9th of July 2024, where they amended the following guidance to reflect a change in operational processes for claim allocation order and the decision-making process for close family members, the Windrush compensation claim guidance, requesting that a claim be considered out of order, primary claimant, Windrush compensation claim guidance, and representative of an estate, Windrush compensation claim guidance. When I looked at that earlier, I thought that's a lot. What does all of that mean? How do I interpret them? Why were these changes necessary for them to even be listed the way that they were? I then reviewed the claim form, the primary claimant. But even prior to that, I looked at the caseworker guidance, which is what the focus is today. It's 106 pages. And some of the categories and information there, I do not think I've ever seen. And one example of such was, or maybe I did and didn't really pay attention to it until today, nonetheless. I'm just looking for it. So if anybody in the call has, please let me know. So one of them, say for example, under education, it has, and this is reference to page 79, education, denial of access to higher education as a home student. The award requirements, evidence, award calculation that I've seen before. What I didn't see or hear about was reimbursement of international student fees. I didn't hear about it because I know somebody who has been affected and could not access higher education. But for international student and reimbursement of international student fees, because you can't prove that you have a right to be here, then you end up paying international fees, you get reimbursed for it. But just the terminology in which was used. Maybe it was oversight on my part before. And there's now a category of devolved administrations. I don't remember either reading about that before. There's now also a section on national insurance contributions. So more categories are being added, but I don't know in essence how they work without reading the entire 106 pages. Yeah, somebody have their hand up. Oh, Garrick, sorry. Yes. Hi,
Yeah,
Garrick. Yeah.
just a couple of points to add to the um, the amendments and the changes that you've just read from 2019 upwards. You will notice currently all the updates can be found in one place, and it took some time to actually achieve that. Push the Home Office to actually do that, because previously we had to just go and search for
Yes.
different places to find information. That it's a good thing now, but also the other important thing that has come out of the new government is that all the previous update there is a warning to say that was by the previous government. Yeah.
Yes.
So everything that was done under the conservative government, the current Home Office have separated those decisions and says, okay, that was published under the previous government. It's good to know that, because what I'll be watching carefully, and I think Tonika will do exactly the same, is to see now what will change in the way the Home Office is now dealing with cases. We're waiting to see some real changes, with the Windrush compensation scheme, and whether it will be announced publicly or we'll just slowly see things materialize, we don't know. But there is a clear distinction between the previous administration and the current administration.
Absolutely. Another thing that I came across earlier in the week when I was doing some research for a different reason was that they're now saying that there will be updates monthly, and they have a note of that on the website. So
Yeah.
indeed, we are looking. Indeed, after the conference, the Labour conference last week, or last week and a half, 2 weeks, both the Home Secretary and the Prime Minister have listed the Windrush scandal within the areas that they will be looking at and focusing on, or trying to redress or address, rather. We'll see just what that means, how that manifests into actions. Because it was also mentioned with other equally scandalous issues such as Grenfell Tower, the blood scandal, the post office scandal.
Mm.
So we will wait and see what comes out of that. But going back to today, for today's benefit, does anyone, rather than us going through, does anyone have any questions about the compensation scheme? Anything that they're curious about, and make it a bit more interactive session?
Just in relation to the document, we always try to encourage people to actually use and read the caseworker's guidance. It is known as the full guidance, that is. And the reason why we encourage people to read it and get familiar with that document is because the caseworkers are using that document to actually process your application. And there are cases where they have not been following the guidance themselves, and we had to challenge them. So if you do not know the guidance, and when a decision is made, you don't know how they arrive at that decision, it is good to actually get familiar with that document. I know it's a lot of reading, and a lot of people just probably won't bother to read it. They'll just read the primary claimant 24 pages and so forth and fill in the application. But the importance of the casework guidance, the full guidance, is that you get a sense of what the caseworkers would be looking for in your application. Uh, and, if they fail to follow that, then you can challenge them.
Thank you for that, Garrick. And before as I said earlier, one of the things that I've always been curious about, so I'm on page 20 of the guidance. And at the very top, it says claimant arrived before 31st of December 1988. Now, only until recently did it stand out to me or stood out to me. And anybody on the call kind of correct me, if you have a different interpretation. It's always been my interpretation that if you arrive between 1948 and 1988, you are of the Windrush generation for the purposes of the scheme and, the descendants after. However, there are distinctions within the schemes which has four categories. First category being if you arrived from a Commonwealth country before 1st of January 1973. And on page 20, it reads, as outlined above, claimants, regardless of their nationality, who were settled in the UK on 1st of January 1973, were treated as having indefinite leave to enter or remain, ILE or ILR, by virtue of the Immigration Act 1971. Meanwhile, claimants of any nationality who arrived after 1st of January 1973 and before 31st of December 1988 were required to hold formal grants of leave. These primary claimants must have a right of abode, ROA, settled status, or have become British citizens. Where these claimants obtained confirmation of their settled status either prior to the establishment of the Windrush scheme or through the Windrush scheme, you should expect to see in evidence, my apologies, you should expect to see evidence in the form of a no time limit biometric residency permit, NTL BRP. Now, why that's important? What does it mean to hold a formal grant of leave? Is that also ILE or ILR? What about Commonwealth citizens who arrived after the 31st, well, sorry, in this case, the 1st of January 1973? There were still CUKCs. Does that mean they didn't get automatic ILE, ILR? I don't have all the answers. I'm hoping we can possibly discuss it and see if we have a meeting of minds. Now, a right of abode can be evidenced by the following documents. It continues on page 20. A UK passport describing the person as a British citizen, which a CUKC citizen would have had. And it would have been the correct interpretation that they were British but by birth, for not being actually born in England, Wales, Scotland, Ireland. A UK passport describing the person as a British subject with a right of abode in the UK. And a certificate of entitlement and or affixed to a current or expired foreign national passport. I'm not a nationality expert, but someone on the call has a bit more experience where nationality is concerned. Can I ask if he can help enlighten us on this point?
Hi, Tanika. Are you referring
Hi.
to me or are you referring to
Oh,
Garrett?
you. I didn't want to call your name to put you on the spot, but I hope you knew I was speaking about you.
Okay, so what's the question? I think you were talking about a few things.
Yeah. So the question is, a CUKC, so citizen of the United Kingdom and Colonies, Commonwealth, who arrived after 1st of January 1973, based on page 20 of the document, trying to understand if you arrived, according to this document that I'm reading, you're from the Commonwealth, you arrived before the 1st of January 1973, you were treated as having indefinite leave to remain or enter by virtue of the Immigration Act 1971. Meanwhile, claimants of any nationality who arrived after the 1st of January 1973 and before 31st of December 1988 were required to hold formal grants of leave. So, the second question, what is a formal grant of leave for the purposes of that sentence?
Right. So a formal grant of leave would be leave that you obtained from the immigration authorities, whether it's, I mean, you have leave that is by permission in the sense of limited leave to remain or indefinite leave to remain, which can mean unlimited. And this is a flexible and ambiguous term. Most people think that indefinite means forever. It doesn't actually mean that. It just means for an undefined period of time. And that definition can come into question in the sense that people with indefinite leave to remain can have their leave taken away if they do something prejudicial to the interest of the UK or something to that effect. But in the context of right of abode, that is a more absolute right that you do not necessarily lose, depending on the context of which you hold it. So, for instance, some people who would have had a right of abode in 1973 may have lost that right of abode before 1983 or right around 1983. I'll give you an example. Richard Black from St. Lucia, he came here in 1960 and he had a right of abode under common law. And then when the 1971 Act came into force in January 73, that right of abode was by statute only under the definition of Section 2 of the Immigration Act. But it depended on his citizenship of the UK and colonies. So you could only hold a right of abode in that context as a citizen of the UK and colonies with the right of abode. When his original colony or country of birth, St. Lucia, became independent around 1979, he then lost CUKC status. And although he continued to have a right of abode, we had this opinion from a nationality barrister. He continued to have the right of abode according to I'm trying to remember which book it was, the nationality law book by Laurie Fransman. Then he would have lost right of abode at around 1983 because it could no longer exist on its own without the citizenship to go with it. So, in other words, when the British Nationality Act 1981 came into force, the only way to hold a right of abode is defined at Section 39. You would either have to be a British citizen, right?
Mm-hmm.
Or a Commonwealth citizen with right of abode under Section 22 of the Immigration Act or Section 21D of the Immigration Act. So all other people who held right of abode, but not by virtue of those sections, would have lost it. So this happened to a fair few people. They lost their right of abode. But I want to say plainly that with the report that came out, that was released last week,
Mm-hmm.
it is my opinion that all of what transpired between those years and what continues to transpire because those laws are still on the statute books means that there is a lot of prejudice that is still happening to people who were in those categories. People who were CUKCs and some people who were not CUKCs, but just Commonwealth citizens who came to the UK or who had, or some CUKCs who didn't come to the UK, but were in British colonies, like myself. Those laws said that you could not come into the UK without permission. You're a citizen, but somehow an immigration law which was meant for foreigners, was applied to citizens on the basis of the color of their skin. And that, for me, means that those laws were implemented specifically to restrict the rights of citizens. And I feel that those laws, those legislation are unlawful. They operated unlawfully on citizens. They were meant only to operate on foreign nationals.
Thank you for that, UN, and thank you for sharing Richard Black's story. But I think that that didn't really answer my question, or
Right. The
the
other part
paragraph
of the
two of
yes, I think the
20.
other part of your question was relating to um Section 1, subsection 5 of the Immigration Act, those who had leave when the act came into force, and it says that the rules shall not apply to them. Is that what you're referring to?
No. So let me rephrase both questions. So if we
Okay.
look at page 20, the first paragraph, the first question relates to that, which it says people who, or i.e., in this case, regardless of nationality, who settled.
Where are you looking at that? I'm trying. Is that in the chat?
Yes, yes, I'm looking at the casework, the Windrush Compensation Scheme Caseworker Guidance, version 17, page 20.
Windrush compensation scheme
It's one
PDF. Or,
sentence.
oh,
One.
okay, so it's two
Yeah,
versions of it here.
sorry, I was. You go ahead.
Page 20, you said.
Yeah, 20. It reads claimant arrived before 31st of December 1988. It's one sentence, about three liner or two and a half.
I've got it now. I've got it in front of me.
So that one, that's sentence and the second sentence, hence the first sort of two paragraphs. The
The
first
the
sentence is my first question, the second sentence is my second question.
as outlined above, claimants, regardless of their nationality, who were settled in the UK on 1st January 1973, were treated as having indefinite leave to enter or remain. That
Yes,
part.
yes,
Yeah.
that sentence,
So that relates to Section 1, subsection 5 of the Immigration Act.
which is 1981, enacted in 1983, the Nationality Act. Sorry, I'm taking
No,
Nationality
no,
Act.
no, no.
You're
The
done.
Immigration Act 1971, which came into force on the 1st of January 1973,
Yes,
Section 1, subsection 5 of that act. I'll read it for you.
please. Thank you. Sorry, my head was nationality from our previous conversation.
I'm just trying to get it up on my screen. Right?
No problem.
Okay, so that section reads, uh, the rules shall be so framed that Commonwealth citizens settled in the United Kingdom at the coming into force of this act and their wives and children are not, by virtue of anything in the rules, any less free to come into and go from the United Kingdom than if this act has not been passed. Weird sort of grammar here, but basically what it's trying to say is if you were settled in the UK before the 1st of January 1973, nothing in the immigration rule shall prejudice your right to come and go from the UK. And as broad as that sounds, I was sent a document just a few days ago, apparently from the Home Office, relating to this. And it's very narrow in scope. It also relates to the 1962 Immigration Act, the definition of settled from there, and the definition of those who arrived before that time. So it's very sketchy and it's open to interpretation. The document that I was sent also detailed a few cases that went to court and how the Home Office uses those cases in regards to this. This is one of the reasons why I believe people are experiencing a lot of difficulties with this.
Yes. Thank you for that. There was something I read earlier in preparation, and I'm trying to find it so I can share the link with regards to said section. But I will come back to it. I will try and find it, Ewan. But
That's,
the question with regards to that, it says you will be treated as having indefinite leave to enter or remain by virtue of that. But then
mhm.
the 2-year rule comes into play. That's
Hmm.
just in addition to that point of if you leave after 1973, when the act came into force 1st of January, for more than 2 years, that indefinite leave to enter or remain would have lapsed. So therefore, even though you would have lived here 20, 30 years prior, 10 years prior, your right has lapsed.
I think that is also, I mean, the document was very detailed, but I think it also, I think there's a caveat to it because somewhere along the lines there was a term referred to as freely landed before March 1968. Not sure if you're familiar with that.
No.
Okay.
But what I read basically, or what I'm looking for, something I've read, and I'm trying to find the link. It had said something along the lines of, if you came prior to 1971, or before the act came into force in 1973, and you didn't basically regularize your status, then you would have lost it. And you've said similar by when the Nationality Act came into force in 1983, 1st of January.
Yeah, that's for people whose countries became independent during that period. So in the 1970s, you had a few countries that went independent, like Grenada, St. Lucia, um, Dominica, etc. So where they continued to have a right of abode, but no longer had CUKC status because they lost it on independence. Um, then after 1983, the Act defined those having the right of abode as only British citizens and those who held it by virtue of Section 2.2 of the Immigration Act or Section 2, subsection 1D. So if you didn't fall into those brackets, then you apparently lost your right of abode.
Which is contrary to what you had just said about the document that said you had freely landed and you can go and come as you like.
Yeah,
But
so
that also relates.
ILE, indefinite leave to enter and remain, are different from right of abode. Right of
Yes,
abode became a statutory right under the 71 Act, whereas before it was a common law right where all British subjects had that right. It was changed.
that part I did not know. So thank you for that personally.
Right. Section
That
2 of the
brings,
Immigration Act defines it.
again, this is where one of my things where I say to people that the Windrush rules or schemes lend themselves to immigration rules. So you need to understand immigration rules in order to understand the scheme. So when you're applying, you know whether you can or you can't actually access or even be successful, the likelihood. But that
I
brings
think, I think fundamentally things have changed since last week. We've all known that these things were racist, these pieces of legislation, but there was nothing tangible that says, here is a detailed report that says that racism or racist ideology was the cause of this. Now we have that, and should we still be playing by these rules? Should the rules that define the schemes of the Windrush compensation scheme and documentation scheme are based on racist ideology? So how do you properly get redressed for the wrongs that you've suffered based on that same racist ideology? You see where I'm coming from?
yes, I do.
Yeah, it's a good point. Just hold that point. Let's bring Egbert in, because he may be raising a point relating to what you've said, you and or what Tanika said.
Egbert, before you come in, yes, Pauline, we that's what we've been petitioning for a long time, for the scheme to be taken away from the Home Office. Whether the current government will, we're waiting to see. One of the many things we're waiting for. And hi, Laurencia, we will come back to you. And please, I hope you remember the question and what you would like to share. Egbert?
Yeah, hi, good afternoon, everybody.
Hi, good afternoon.
I wanted to ask you a question. What's the difference between IR and the no time limit?
So I can answer the no time limit, you, and if you want.
Hello?
Yeah, it's a really good question. And you would ask yourself, why doesn't the Home Office define these things on their website? You know, so that it's pretty there because it's a good question. Go
Yeah.
ahead,
The thing why
Tanika.
I'm asking the question, because before you had the ILR and the ELR,
Yeah.
and then
Hmm.
they scrapped the ILR. I think it was before in the 80s, and they made it the NTL. As you said, the ILR wasn't. You said it wasn't indefinite. Indefinite could be curtailed. Are you saying that the NTL could not be curtailed?
So
Um,
I can answer the NTL if you want, Ewan.
yeah, go ahead.
So the NTL, no time limit, is what people are now given when they apply to the Windrush schemes for rectification of their immigration status.
Yeah,
But
they've been giving that since the 80s, Tanika.
but when the scheme first, I'm speaking of the Windrush schemes, the scandal only broke
Okay.
in 2018. I don't know what went on in the 80s. I can only speak to when I became involved, which is from 2019, and my observations with the Windrush schemes, which again started in 2018. So from that perspective, NTL only came in a couple years ago, not even from 2019. Before you were given British citizenship through the Windrush schemes as rectification, that did no longer do. Now you get a no time limit, which means if you're in the country, you get no time limit. Some people, after they've received that, they have to wait 12 months still before they can naturalize as British.
I
But
understand.
but
What I'm
can I
trying to say,
let me
what
for
I'm
the
trying to
benefit of others who are on the call who may not know this and those who may watch it.
the point I'm trying to the what I'm trying to get to clarify from Ewan is he said earlier on the indefinite leave to remain could be taken away. It wasn't indefinite per se. I think that's what you said, Ewan, earlier on, yeah? So the indefinite leave to remain, they scrapped that back in the 80s and they issued an NTL to anybody. It doesn't matter if you're Windrush or not. Yeah. So is that NTL? Does that mean it could still be taken away in on the same way that Ian inferred that the ILR could be taken away?
No, so my understanding is okay. So let me just back up. Indefinite leave to remain is still issued. You
Is
get
it okay?
you get indefinite leave to remain in the United Kingdom after you completed a series of um, leave with time limit. So, for instance, if you're on a 10-year route, if you're not a citizen of the UK or a British citizen, and you're on a 10-year route to citizenship, or you're the spouse of a British citizen, and you're on a 3 or 5 year route to citizenship, at the end of that, you can apply for indefinite leave to remain. Well, that means that you're a permanent resident in the United Kingdom. And at some point after 12 months, you can then apply for, and in some cases, I believe you can apply immediately for your citizenship, right? No time limit is a bit more sketchy because the Home Office uses it in different ways. I've seen where people who have a right of abode in the UK are granted no time limit because the right of abode that they continue to have since 83, they will have for the rest of their lives. It won't expire, right? So that's where it's a no time limit. I'll give you an example. Um, Richard Black's ex-wife, who married him in 76, she got a right of abode from being married to him under Section 2, Section 2, subsection 2 of the Immigration Act. It's now reclassified under Section 39 of the Nationality Act, 81, and she will have that right for the rest of her life as a Commonwealth woman who was at any time married to a man with right of abode. So that is an example, one example of no time limit. I believe there are some other examples, but
Yes.
Okay.
my point again is they should actually define these properly on on the website.
But
All right, thanks for
Mhm.
explaining that, but I wasn't aware there was still issue in the ILRs. Okay. Can I
yes,
go with, can I go with one more question, then I'll shut up?
before you do, Egbert, please hold it.
Sure.
You and you're 100% correct, and there are different variations of how no NTL is given. So, for example, one client, a Windrush claimant, a returning resident, before he can be issued his NTL, he was told that he has to come back to the UK first to get it.
Yeah.
And then, if he wanted to come with his partner would then have to apply as a normal spouse through that route with children to then pay the normal immigration fees rather than coming as a family, contrary to Richard Black or the lady from Trinidad with her family. I can't remember her name.
I can't remember.
Yeah,
Mahia,
that's the woman. Sorry, I'm not going to try to pronounce her name because I think I'll probably get it wrong. Then there's another instance of NTL. He supported a client who was brought back from with the Home Office's help and given NTL, but was able to apply instead of waiting 12 months for naturalization. Got NTL and then was able to apply for naturalization almost immediately. So there are different ways indeed of how it's being applied, and there's no particular one definition from all these instances I've seen, for example. But it's within the schemes. So which interpretation is correct?
well,
Uh,
the problem I see, and the problem I've been explaining since 2018 with immigration lawyers up and down the country, is that when you operate in silos, when Liverpool advocates for Windrush or some other firm in London or one in Wales are not sharing information properly, the only people that are sharing information and knows all the details and all the facts is the Home Office. Now we can't see inside their organization, and we don't know what's happening. So if we don't share information properly, they will have us swinging left and right in the dark, which is what they have us doing right now.
yes, unfortunately. UN, forgive me, maybe I am, my interpretation of this is still really, it hasn't come together as yet. On page 20, the second sentence, which is what I asked earlier. Egbert, I haven't forgotten that you have a second question, and there's someone else that wanted to ask a question too. UN. So it says, meanwhile, claimants of any nationality who arrived after 1st of January 1973 and before 31st of December 1988 were required to hold formal grants of leave. My question is, what about those Commonwealth citizens who arrived after 1st of January 1973, possibly even a child or as a child? They were still CUKCs. So not only were they Commonwealth, they were also CUKCs. Because you can be a Commonwealth citizen but not a CUKC.
Yeah. So I can give you an example of that.
And linking that to the first sentence or first paragraph, which says if they, as any nationality became before the 1st of January 1973, you by virtue had indefinite leave to enter or remain. To enter meaning you once you enter you can, well, you can go and come.
Mhm.
Well, to enter means to come in. To remain means to stay. It says not both. But anyway, sorry, I digress. That's a different interpretation and curiosity. Yeah, UN.
So yeah, I was trying to figure out what was the question you wanted to ask me about that. You said some who were CUKCs.
Yeah, so you come in after the 1st of January 1973. You enter after. You're both Commonwealth and CUKC.
Yeah. So an example of that would be, let's say, somebody from Antigua or St. Kitts, because they had CUKC all the way up until 1983.
Mm-hmm.
Those were the two ingredients. You needed CUKC and you needed right of abode to become a British citizen under Section 11(1). So everybody born in the United Kingdom before 1983 had a right of abode in the UK. They were also CUKCs, and they went on to become British citizens on the 1st of January 83. Somebody from St. Kitts, for instance, who was resident in the UK, was a CUKC, had a right of abode under Section 21C of the Immigration Act, based on 5 years residence here, or perhaps 21A, because their parent was also born here or something to that effect.
Mm-hmm.
They went on to become British citizens. Now, when I use Richard Black as an example, he lost CUKC on the 22nd of February 1979 when St. Lucia became independent. During the early 1980s, when Antigua went for independence in November 81 and Belize sometime that year, the British nationality bill was already in Parliament, and there were special arrangements made for Antigua and Belize to retain CUKC status at that particular time to help the people from those countries that were already living here to retain that status and go on to become British citizens. St. Kitts also benefited because it did not become independent until September of 83. Okay, so people from St. Kitts, Belize, and Antigua had CUKC status on the 31st of December 1982. And if they had the right of abode as well, they crossed the threshold into 83 with those two ingredients. So my grandfather, for instance, I know a wealth of people from St. Kitts and from Antigua who benefited in that way. Okay. So
thank you very much. Yeah, yes, I'm listening, Ewan.
I was just hoping that helps to answer your question. So then you would have found that some people would not have had that, like Richard, like people from Dominica that lost it in 78, people from Grenada that lost it in 74 when they got independence. So, and that's in the British nationality law books by Laurie Fransman. I think you have some by Laurie Fransman and some by Ian MacDonald as well.
And it just tells me that I need to go do some research and try to understand that a bit better.
Yeah,
but
but just to make a point, just to make a finishing point here, what I'm saying, because I was a CUKC on the 31st of December 1982, and I did not live in the United Kingdom, so I technically did not have a right of abode. And the reason I didn't have a right of abode is because of the Immigration Act curtailing my citizenship rights. And that's why I say, how can immigration law steal the rights of a citizen? They are not meant to do that. You see my point?
Well, wouldn't that be the argument for all Commonwealth nations?
All CUKCs,
Precisely.
all citizens, not necessarily Commonwealth nations, because after you become independent and you lost that
CUKC.
citizenship of the UK and colonies, you're no longer a citizen. And so the point I'm making is Keir Starmer was CUKC in 1980. I was a CUKC in 1980. Laurencia, who's on this call, I've spoken to her. She was born as CUKC in St. Kitts in 1976. So we were all CUKCs, but some of us had the operation of racist immigration laws that took away our rights to come to the UK without permission. So you've imposed permission on citizens based on the color of their skin. That is the point I'm making.
Isn't that also contained in this what was the Commonwealth Immigration Act of 1962? UN?
It started in 62, but it did not affect CUKCs until the 68 Act.
Yeah.
The 1968 Act was designed to curtail the rights of CUKCs entering the UK because CUKCs were being expelled from East Africa, Uganda, and Kenya. Well, mostly Uganda, but the East African Asians were being kicked out of Uganda by Idi Amin. And they were coming here because they had CUKC passports. Britain saw it as an influx, and they legislated immigration policies against their own citizens based on their skin colors.
Thank you for that, Ewan. Garrick? Sorry, go ahead, Ewan. You wanted to add something else?
Sorry, Egbert had another point, didn't he, before I come in?
Yeah, but that's why I brought you in. I figured that would be the reason.
The only other point is that from 1968 until 2002, when the British Overseas Territories Act came into force, that's when the rights of people from British overseas territories was restored. So for that 40-year period, from 68 to 2002, I believe that's 40 years if I can count correctly, or something to that effect.
Yeah.
I'm too impassioned right now to even do the math. That period is where the rights of citizens were restricted for entry into the United Kingdom, and it's based on racist immigration policies. That needs to be repealed in its entirety. And that is what I will be saying to the Home Secretary when I make my speech on the 16th of October.
Thanks, Yuan. Egberth? And then we go to Laurentia.
I'm hoping I'm going to try and be quick with this one. Ewan, that's very enlightening what you've just said there. Thanks very much. Yeah. I wanted to go back to the you were talking about the racist ideology, the scheme itself, and this scheme being in the hands of the Home Office and no movement. If we can go back to the caseworker notes, I was actually looking at the other day. Tanika, you guys mentioned it. Garrick mentioned it. One of those sections in which I'm trying to understand as to why it happened and how it happened is the loss of access to employment. Yeah. Have you got that in front of you, Tanika?
I do. Which page?
I don't know what page it is, but if you, I don't. My mind's not numbered. I think
79, Tanika, that deal with education.
Thank you.
In that loss of access to employment, the Home Office states very clearly between January 1997 and 2008, Section 8 of the Asylum and Immigration Act applied to work, right to work checks conducted during this period. Now, from my own personal experiences, that's when this whole saga commenced in direction. And what I find very interesting is on the back end of the report that was released by the Home Office the other, which you mentioned, is that at that particular period, the Labour government was in power. Yeah, they're the ones, in my view, who initiated all saying, yeah, it was that particular piece of immigration legislation that triggered this whole thing to a lot of people who were rightfully and lawfully going about their business in the UK. My point is that when you keep going down that list or that chapter, it then gives you definitions or criteria for claiming compensation under that category. And it moves on to say claimants may also state, or you should consider making such claims under other categories, such as impact on life or housing. The point that I'm going to make here is that if someone's status to employment was in question to get employment, then surely their status to get housing would also be in question. So how could they then go and make a claim under that category on their claim forms? Do you understand what I'm saying?
Yes, I do.
So the Home Office is there quite squarely putting the blame for this on this trigger in the years of the early government, of the Labour government. Now Labour are back in power and they're going to be dealing with this. If this is a racist ideology within the government of the day at the time, and it was covered up between 1997 and 2008, this was still going on in 2016. You had the Home Office sitting on this all this time. Labour are back in power, and we're asking Labour and the Home Office again to solve the problem which they created. I know John Major's government passed the legislation, and I've been saying this for many, many years now. Not only that legislation, but a whole stack of legislation which were used detrimentally right, to a lot of people of color. And I did the research in those years, and I challenged a lot of MPs, but I'm a bit concerned as to how we can be asking the people who created the problem to solve the problem when they've been covering it up for the past 20 odd years. So,
well, yeah, thank you very much for your contribution, Egbert. This is something that we've said before on this platform, and thank you for bringing it up again. You just reminded me of a case I had, and I helped someone with regards to loss of employment. And when the Home Office got back to us, they said, well, we did not require employers or even landlords to check before, I think maybe 2014 legislation came into force.
Yeah.
But here is saying before 29th of February 2008.
yeah, exactly.
So there's lots of discrepancies and inconsistencies. Egbert, I don't know what to say. I don't feel as though I have the right answer.
Okay, I understand. Let me spin this out a little bit further. Yeah, hypothetically, let's say someone was in work. If you read that section properly and try to understand what it's saying, if someone was in work and they lost their job, then the Home Office would make compensation. But if you lost your job, yeah, and you're applying for new jobs and you were failing and you had a negative return on your status inquiry, then the compensation moves to either the impact on life or the housing. But think about this a minute. If someone was in employment and they lost their job because their status was negative, they're also, let's say, social housing, yeah, the status would also be negative. What about someone with a mortgage who couldn't get employment to pay their mortgage? Yeah, let's roll this on. So if someone is
Hello.
did victim,
Hello.
okay, so therefore they're now homeless. If they're homeless, yeah, the compensation the Home Office is offering for the homeless category.
Hello.
It's dropped out. His internet is dropped out.
Yes, you have your hand up, Garrick.
Yeah, I was just going to make a couple of comments on this point around the racist report that we referred to, where skin color was used in order to prevent people coming into the UK. We always suspected that, but we didn't have all the written evidence as this report actually states. Now, Tanika and I was having a conversation prior to coming on the call about, you know, this whole idea. How do we redress this? So legislation is in place, or was in place, and still in place because those laws are still here. And we've always said from the time we started Windrush that you needed a new piece of legislation, preferably a Windrush Act, to undo all the damage that the various pieces of legislation have done and impacted on Black people. The way that we can address this report and what you just said, speaking on the 16th to the Home Secretary, we still have two pieces of legislation that does carry some weight. The Human Rights Act is there, and the Equality Act. Yeah, and I'm just wondering, Tanika, as lawyers, how we can actually use those two pieces of legislation against this report. So that might need some conversation and you know, bringing other people into the mix. But certainly there is a need to challenge the way that successful government of use legislation against black, and I will say black people, political black. So no, that's a big agenda that need following up on.
I think just to interject quickly, I think you would need some test cases, especially like mine, just to show or to demonstrate, or to seek some sort of declaration on how these you can use immigration law to curtail the rights of the citizens. And it's funny you mentioned the Human Rights Act, because back then it obviously didn't exist. It came into existence in '98. And it's for that reason I believe that the rights were restored to the overseas territories just 5 years after the Human Rights Act, because those challenges would have come into play. So I think it definitely needs test cases to go up against this. And lawyers need to have that peak interest in this area.
Yeah.
Not only that,
Ewan, can I ask you a question there?
Egbert, hold on, please. So,
Sorry.
Gareth, remember we had looked at this, well, a few years ago now, even though our organization is not that old.
Yeah.
Where we looked at similar schemes and the operation of similar schemes, which has or lends itself to immigration rules and policies and treaties, such as the Hong Kong scheme, the EU scheme, the Afghan scheme, Ukrainian scheme,
Syria scheme.
And I'll leave that there for purposes. That's not what today is meant for, but yes, absolutely. And UN, thank you.
And the other point, Tanika, that was just mentioned in relation to checks being made prior to the legislation that imposed the right to employers to do the checks. Prior to that, there was no piece of legislation that require employers to do it. So how can we challenge the Home Office if they're using those principles of cases back in the 70s and 80s?
Well,
Gareth,
I
don't have you. Egbert, we will invite you in momentarily. And Garrick, I don't have an answer to that. It reminds me of a similar case again that I helped another claimant with, where we then wrote off to the Home Office for information. So, for example, through subject access requests to get information, and the response was, "Oh, our records only go back to 1985," but yet people have the evidence from 1948 onwards up to 1985 when their records exist for. In addition to that, they send you to the National Archive, which only reflects registration of naturalization certificates. Going back to page 20, the first two sentences or paragraphs, however you want to look at them, there are lots and lots of ambiguities. You've alluded to them earlier. And you'll need immigration experts, nationality experts in order to understand and apply. Because unfortunately, when people do apply, the rejections are based on said policies or legislation, and ordinary citizens are unable to apply them without having some sort of support. Before we go back to Egbert, I'd like to invite Laurencia to come in. You've had something to share and a question.
She'll need to unmute.
Hi, morning.
Hi, morning or afternoon.
Good afternoon. Sorry, I'm Lawrence here. I'm from St. Kitts. I'd just like to share something that me and Ewan is going through right about now. I filled an application for my mom on behalf of her grandfather, who was born in Anguilla.
Laurencia, can I just ask you to pause for a minute?
Sure, no problem.
The call is being recorded and it will be put on our YouTube channel. So please do not give any personal information identifiers that you don't want in the public's domain.
Okay.
All right, thank you.
Okay. The passport application was approved. Then I applied for 5 of my siblings. They were all approved. Then suddenly, I applied for mine after. They said I was not eligible because of the independence we had in 1983 of September. Then suddenly, early August, I received 2 emails, which the passport office has been recalled 2 of my siblings' passports, stating that before independence, females won't allow to pass on passports or British citizen to their children until after independence we had. So I had three siblings born before independence and 2 were born after. I did a cousin from my aunt and they all get through. So I was wondering if any one of you there can enlighten me, give me some suggestions, because they just asked back for the passports and they did not even say, well, you can register. They did not give us any further instructions. They just asked for the passport. And if they wasn't returned in 28 days, they would cancel them on their end. So I would like to know if the 2 siblings so that we call the passport for could register or some other option to put stay with their passports. That's all I have to say. Thanks.
You're welcome. I don't have an answer. That's the simplest answer I can give you and the truth. However, I've encountered a similar situation from a British overseas territory. Only a couple months ago, the person was relating it to me. And they applied for her and her children. They got their passports because they're still British. The king is still the head of state for Bermuda. However, when she went to apply for her father, they said the father can't. And this is to renew the passport. What you've just described, Laurencia, it seems as though you'll need an immigration specialist. Unfortunately, we are not yet in
Okay.
a position to give immigration advice to that degree. I am a paralegal for immigration solicitor, but even within that capacity, my knowledge is limited. I will have to consult him, and that will be outside of the scope of the Windrush schemes and what we are.
Mm-hmm.
If yes, so that's unfortunately as much as I can offer at this moment with regards to your query. UN, do you have anything you want to add?
Oh yeah, definitely. So I am familiar with her case,
Yes.
and again, I go back to the discriminatory laws, and I will say this specifically for the purpose of the YouTube broadcast, because what women experienced before 1983 was purely control, and it was designed. The nationality laws were designed that women could not pass on citizenship to their children born outside the UK and its territories for the purpose of restricting them from other men. It's basically a punishment that says, well, if you go with foreign men and you go to, I don't know, let's say Jamaica, for instance, you have children there, those children are not going to be British citizens because you can't pass on your citizenship outside the UK and its territories. The difference here is that Laurencia was born inside British territory, which is St. Kitts, and her mother as well. So St. Kitts was British territory at the time. The colonial state was St. Kitts, St. Christopher, Nevis, and Anguilla. And when she was born in 76, Anguilla was still part of the federated colonial state. Anguilla split in December 1980. In 1980, Laurencia's great grandfather is from Anguilla. Her grandmother and mother's claim comes through Anguilla. And there is a special piece of legislation called the St. Christopher Nevis Modification of Enactments Order that says if you were CUKC and you have a remaining connection to, or you have a connection to a remaining territory on Independence Day, you will continue to be or to have British dependent territory citizenship, which her mother did. But the fundamental question is, what her mother had, could she pass it to her, to Laurencia? I say the answer to that is yes. The Home Office is saying women could not normally pass on citizenship to children born outside the UK and territories. And again, she was born inside. So I did a subject freedom of information request to the Home Office, and I asked, what happened to, what is the case with UK women before 1983 who had children born in Bermuda, the British Virgin Islands, and other territories? What did those women do with their children when they were coming back to the UK? Did they register them? Did they, could those children get the right of abode from their mother? What is the answer to that question? I think that the answer is fundamental to Laurencia's case, because her mother had something, okay? And she was able to transmit that something to the other children born after 83, when she was clearly a British citizen and defined in law. And what we want to know is, could she have passed that something to her? And how did UK women pass it to their children? Because those children would have been born CUKCs in the British Virgin Islands or St. Kitts or Antigua at a time before 83. But when those women are coming back home to Britain, those children would not necessarily have a right of abode in the UK, or would they? So those are the fundamental questions we're trying to get answers to. And as I say, we sort of work in silos, and the Home Office knows the answers to all these questions. But for the most part, a lot of people on the outside don't know the answers.
Thank you for that, Ewan. You reminded me of the interpretation that prior to 1983, the Nationality Act, that status was, or right of abode was passed from the father only, at least in the UK, in England and Wales or Britain, it was only through the perennial line,
Paternal.
not the maternal line. So when you spoke, I was wondering if that was the same thing for CUKCs. In my head, it will make sense for it to be, because if it's happening in Britain, then it will also happen in the territories.
Right.
Therefore,
And
may
so their languages could not normally pass
no,
on citizenship to a child born outside the
no,
UK.
hear me out, please, because if they were still British, i.e. CUKCs would have been at the time still British, but by birth, then therefore maybe that's how the male siblings were able to retain theirs.
No,
Said
because it's coming from the mother. It's not just because the children are male. The
from the
status is
father,
coming
from the
from the
father.
mother. No, the status is coming from her mother.
Okay, okay,
The father does not have a connection to Anguilla. So
okay.
the great grandfather, the mother's grandfather, was born in Anguilla, a remaining territory. So that's where the connection comes from.
But you could only pass it on once. You can't pass
No,
it on
no,
to
no, no. You can
grandchildren.
pass it perpetually inside. So with the St. Christopher and Nevis modification of enactments order, it refers to a parent or grandparent being born in a remaining colony.
You see?
So
And that,
that's how her mother relies on her grandfather to get that.
okay.
But it's something that she got at birth. It didn't happen after birth. She got it at birth by relation. So if she has something, my question is, if she has something, why can't she transmit that something? And if she can't transmit that something because of discrimination, with the new legislation that came into force under the Borders and Nationality Act, historical legislative unfairness, that is what prevented her from transmitting the something that she had, right? Women couldn't pass it on. So now that that law is in place, why didn't the passport office suggest registration under special circumstances, historical legislative unfairness category of the British Nationality Act?
Oh my gosh. Okay, so that three things coming out of there. Did it mean one thing for Britain, another thing for CUKCs based on nationalized legislation, as you've just mentioned, the one for still I can't remember the last piece of legislation you mentioned.
So, so
That's
the
one. Two, um, this just shows the complexities in understanding the schemes and application to the schemes of any specific individual or individuals. And thirdly, there's 65 Commonwealth countries affected. The question then for individuals like us, advocates, UN, do we then have to apply each of those 65 Commonwealth countries' legislations in order to understand everyone's individual cases, or should it be the Home Office's job and onus to make it simpler? Because not only are there 65 Commonwealth countries affected, there are the European countries which are not included in that 65. So there, for say for example, there are 20 European countries affected. That's 65 plus 20.
well, I'm not at all concerned about Europe because, and I'll say this plainly, because when the right of abode in the UK was being removed from 4.4 million people in 20 remaining colonies around the world, it was then given to 400 million Europeans. That right of abode was given to them through freedom of movement.
Mm-hmm.
So you took it away from 4.4 million and you gave it to 400 million and talk about immigration control. So it was never about the numbers. Let's just be clear about that. It was never about the numbers. What it was, it's all racism. The easiest thing to do is to reverse the legislation. That is the easiest thing to do. What is required to happen now under the historical legislative unfairness route, and notice that the title, historical legislative unfairness, if you Google it, the new legislation comes up. The historical roots of the Windrush scandal, right? The titles are very similar. But I say that to say that under the historical legislative unfairness route to register as a British citizen, you have to prove to the Home Office how the laws discriminated against you. You must have a comprehensive understanding of very complex legislation over a long period of time. And you have to set out your case to them. And then it gives them the discretion to say, okay, well, you look like you've been battered over the head enough. Let's give it to you or not. And that in itself is unfair. I can see Garrett nodding in his head. He agrees.
I'm going to make a comment. When you finish your points, I'll make a couple of comments.
Yeah, I think I'm finished on that now.
Yeah. I mean, the facts of the matter is this. What you've just said, you're waiting for the Home Office to respond in checking, British women, children born in the Commonwealth countries, etc. And that would be all the Commonwealth country, not just one particular country. And we do see the distinct difference between people of white skin from the Commonwealth country and people of black skin. We see that. We see that with Canada. We see that with Australia. We see that with white South Africa. We see those differences. Yeah. We've always made this point that the scheme that was designed to address the Windrush issues, here lies a problem. We've been having this conversation about immigration issues for the past hour and a bit, etc. The Windrush compensation scheme doesn't allow individual to go to a law firm and engage with specialist immigration officers to deal with this thing. That's deliberate. That was never in the plan.
There's no legal aid. Is that what you mean?
And we're fighting for that. And part of the Windrush manifesto is about getting legal representation. That's so important. if you look at all the current scandals, and I'll just use the post office one as one example, in terms of the approach that the government are using in dealing with the post office scandal, and where they've placed they haven't put it in the home office, they've put it in the business sector of the government. Yeah. And so, what we're actually fighting for is something similar, for it to be removed from the home office. But also, it's not just the removal, it's also the other bits, because, the ordinary person cannot really deal with all these complications of historic immigration legislation and rules. They can't deal with it, and there's no provision to do so. So we do need a radical change. And I was saying to Tanika earlier on today, what does it mean when the Prime Minister in July made this statement regarding resetting Windrush? We want to know what that actually means, and when will that reset take place? When will we see evidence of the reset? But more importantly, who are the people sitting in number 10 engaging with the government over these issues? Because that is so crucial. We don't want people to be having private conversation in number 10 and putting things forward relating to, to resolving Windrush compensation scheme. And so, it's imperative that, these conversation, we take these conversation to where it actually will make a difference with parliamentary, with MPs, with government ministers, etc. We need to do that because, we've just outlined some of the challenges that we cannot resolve. No ordinary Windrush application person can resolve these issues. We do need, far more legal support on these cases, in particular the one case that you just referred to from St. Kitts. And you can multiply that with other cases. You do need legal support, and legal advice costs money. So the ordinary person could not pay for the legal advice that they need. It have to come with a new package.
Thank you for that, Gareth. And Ewan, thank you for that. You had me looking at the historical legislative unfairness, the act or information on it. And one said piece of information that I came across was that it covers scenarios where the law did not treat men and women equally or did not treat children of unmarried parents in the same way as children of married parents. And this I'm looking at Stevens and Bolton LLP's website, and it says to determine whether other cases could fall within the category, and the specific category is the British citizenship, section 4L, and that's the British Nationality Act 1901, section 4L. If other cases could fall into this category, we would consider whether the legislation concerned treated one group differently to another, particularly on the basis of a protected characteristic, age, disability, gender reassignment, marriage and civil partnership, pregnancy, maternity, race, religion or belief, sex, sexual orientation. Then that prompted me to go to the government website, which has information on that. And I put a link in the chat to it. This is registration as a British citizen in special circumstances. This is version 2.0. Maybe, Laurentia, I would recommend you have a look at this policy. It was published for the Home Office staff on the 14th of October, 2022. Maybe between you and it may inform your situation a bit more. I don't know.
We have looked at this, and what we're saying firstly is that when they threaten to withdraw the passports or tell her that she doesn't She doesn't qualify for the exact same thing that her siblings have, who were born around the same time from the same mother. What they should have said is, you consider registration under this route because you're actually saying that her mother couldn't pass this on. Gender discrimination. Now, it's interesting because you mentioned also discrimination on the basis of special characteristics. Race was one of those. And without that report that was released last week, it is very critical, that report that now says that racist ideology was the cause. Because when I was at court back in 2012 on this very same issue, and the Home Office was trying to remove me from the UK, I made representations on several grounds, and one of them was race. That I was not able to rely on that. I was only able to rely on the fact that my grandfather was a CUKC, and perhaps the Secretary of State did not consider Section 2 of the Immigration Act properly. So now with that report, you can now rely on race properly. And the new legislation, the historical unfairness, legislative unfairness, talks about race. So the Home Office, and they corrected this 2 years ago through legislation. So they already knew that there was racist ideology. The report had already told them this, but their intentions was to bury this report so that you or I or Laurencia or anybody else could not rely on this report to prove to a court that we're going to rely on race as the cause of our experience. And we should be British citizens today because of that experience. So I want you to see how critical it is that that report was released. That report that they fought with a nail to suppress.
UN, well, I share and echo your sentiment. I do believe that we all know, as I believe Garrick said it earlier, we've all known this for a while. Whether we were able to prove it was something else.
What you know and what you prove is two different things. So what I'm saying now is, which one of these big bad lawyers around the UK is going to come up and say, here's a test case, look at what Laurencia's experienced. Here's a test case, look at what UN or others have experienced. Their experience of British nationality law or British citizenship or whatever status they should have had or had was different fundamentally to that of a person with white skin. And are we going to take on the challenge and bring this to court? That is what should be happening right now.
Well, let's watch this space. Let's keep working hard, doing what we're doing. And we can have a conversation again, forwarded to the same point which we have had offline, UN. And it's constant. Unfortunately, you and I have had many conversations. You know how I feel about the matter. So I don't believe this is a space for me to even say much more. Hence, I'm not going to. On that note, I'd like to invite Egbert. You had a second question. We have 20 minutes left for this afternoon session.
Egbert, you're muted.
My internet is a bit unstable. Sorry.
Yes, you went out before.
I've just posted something in the link there. Historical background information on nationality. It's very interesting read. Yeah.
Thank you. Yes, see.
Yeah.
Thank you.
Ewan, are you still there? There's two things I want to say. When you're talking about treatment of race, etc., in the context of the Windrush, it's something that I've always said. And I've said it over and over since around about the mid-90s. And there was a lot of dynamics going on that brought it about. But in looking at what you're asserting the test case, etc., etc. I'd like to point you to a particular piece of legislation which was passed in 1996, and that was the Hong Kong War Wives and Widows Act 1996. If you have a look at that and you look at it in the context of Windrush and the treatment of the people, as you say, of different color, can you hear me still?
Yes, continue. Yes.
I understand what Gareth is saying about the Australians, New Zealanders, all the white people. But if you have a look at that particular piece of legislation, also passed in 1996 by the major Tory government, and ask the question, why were Windrush people treated any differently? Yeah. If you have a look at it and you see it, then you probably understand why I'm asking the question. The other thing I was going to say is about operating in silos is that if you were to look at Windrush, I've said it over and over and over since the late 90s, early 2000s, there must have been a trigger point for most of the, I like the word victims, I use the word sufferers, the people who suffered the experience all of a sudden. There must have been a trigger point either by something they did or a policy of government or an attitude. And when, for example, the Labour government came into power and said, okay, everybody, Tony Blair and Gordon Brown was screaming about immigration, we're going to check everybody's status in the UK. There must have been someone within the Home Office who was either appointed to do that, and why were they giving out misinformation? There must have been a trigger point in someone's to bring this all about. So what I've said with Roland, I don't know where Roland is now, but when I've discussed with Roland before, is if you were to go through the Windrush category headings, and every heading, homelessness, housing, loss of access to employment, etc. When did the person commence having the experience? Was it in 1994, 1991, 1997, 1998, 2010? And then you will get a pattern, yeah? And that would define what you would say either class action or individual cases. And you could see clearly what's been happening. And I suggested that this be undertaken throughout all the advocates, right the way across, acting for Windrush. Go through your files, individual cases, no names, etc. But when did it happen? When did it commence happening? What was the trigger point? What date, what year, etc. And then from there, you could go forward, compile your cases, and either go with an individual case or a group case. You'll see the pattern, and it will answer the question. And it will absolutely clarify the point that Ewan is making, absolutely on the basis of race and by the admission of the Home Office itself on the report it released last week. That's it.
Thank you very much for that, Egbert. I think this will be a good point to start concluding. A lot of us on this call, we have many lived experiences, many speculations, assumptions, facts. But my question to you all, how can we make that be worth much more than what it is right now? Like, how can we enable our voices to be heard and justice, not only for ourselves, but for others, or for the changes that we're trying to achieve, to see? It's my premise that the treatment we see and receive today is merely one of the legacies, the ongoing legacies of slavery, colonialism. Why, if that was centuries ago? Just food for thought. We may not be able to do what is needed alone, This government, albeit there were successive governments that has caused the problems we see today, this government, those in power, the people who were there today, they seem keen on changing the past. They seem keen on righting wrongs. We just have to wait and see. They haven't been in power very long, but they have made strides, much more than the previous government has done in years. If we're just looking on an evidence basis.
I'm gonna ask
So
you for a little bit of evidence on what you just said. What
yeah,
you just said.
I'll sure, I'll bring you in a second, UN. So is more needed? Absolutely. Unfortunately, we can't really say until we see, or maybe a certain time has passed. Well, okay, you should have been able to do way more than you have done, for example, in the last month, the last year. They've only been in power a few months. UN?
Yeah, I was just asking that because you said it seems like they're doing more. So I just wanted to know what has that manifestation of more actually been. I don't see anything yet apart from soundbite, and I'm until I see something tangible, I'm not gonna fall for any rhetoric. I'm not doing any party politics or any of that juggling. Let me see results because I have been suffering for years. Many of the people here has. I see Roland here in the chat. This man was born in the UK and excluded from coming back to his own country and for many, many years. So until I see something happening, I'm not giving any party any praises. They need to just fix it.
So thank you for that. And I agree. I'm not giving any party any praises, as albeit I am part of the Labour Party. I am for the people. I'm about justice. So as I've said, the Labour government contributed to the Windrush scandal as we know it today. As of the 31st of December, after the period of registration has elapsed, they're well estimated that over 200,000 more people are going to be affected by what's now called the digital Windrush scandal. So this is by far something that's happening within the current government's um, tenure, for want of a better word, or when they're in office. What are they going to do about that? I'm not. What I have seen that have changed is acknowledgement, both by the Prime Minister and the Home Secretary. Okay, you've acknowledged, so did the others. What are you going to do about it? And I've said this before. But again, I also appreciate they haven't been in power that long. I'll be the first to say, well, hey, you're not doing enough to whomever will listen. So just to make that clear, that I wasn't singing anybody's any praises or anything like that. But I'm hoping for change, just as everyone on here is. Because if we give up hope, then what do we have?
Just before we wrap up, Tanika, we've got Augustus has joined us from Canada.
Yes.
And just say hello to Augustus and welcome to our Q&A. This information will be out on YouTube, so you can play it again and listen to the conversation. We've been focusing on a couple of things. The Windrush compensation scheme, the piece of legislation that's in place, and then we started to talk about the racist report that was released a week ago that confirmed that the government of the days were using laws to restrict and control, black people, etc. And now we got onto the conversation about what we might be able to expect from the new administration. So this is the time now to reach out to your MPs and make your point known to them, because we want to see some changes. We don't know when those changes will come, but we want to push for those changes. And Roland will give you some information in a minute around the 16th of October, which is going to be our next event. But again, we want people to come forward. Still, there are issues with people coming forward and making application. There are still many people who are very fearful of coming forward and reluctant to come forward because the stories they hear about, the issues and challenges that people experience, they're just put off by identifying themselves. But we do want people to come forward and reach out for some help and support. As we said previously, we're not lawyers, but we on the basis of advocacy work and supporting a Windrush application, this is the place to come.
Thank you for that, Garrick. Again, I echo and I repeat myself that we are hopefully in a period of change. That is what this government is about. Let's hold them to account. Reach out to MPs indeed. It's a top-down approach, it appears. Let's hold them to it. The top is committed, then let's hold our individual MPs. I plan to hold my MP to account and get her support. I'm not affected, but I support anyone who is, who has been or who may not know that they are. And for example, my MP is committed to helping them too. So maybe your MP can help you too. So please do reach out, as Garrick already said. We can only do what we feel is in our power to do, but that doesn't mean we can't try or we shouldn't try. We're here today because we can and we want to help. This is a collective issue. Unfortunately, one of the things I keep thinking back on is during slavery. How did you control the masses? How were slaves controlled? I shall not go further on that point. But I want to say thank you for everyone who contributed. Thank you for your questions, queries, suggestions. Thank you for your time. I hope this was enlightening and insightful. I personally found it that way, and I have learned a lot this afternoon. Thank you, UN. I call UN our resident nationality expert because I am not really good with nationality. And I think that's from UN's 20 years of trying to rectify his own status. So, thank you.
Tanika, can we hear from the person who's got their hand raised?
Yeah, I was going to say, Tanika, just
sorry, I did not see somebody's hand raised.
Yeah,
That's
so it's Roland, and then Tanika, any announcement that we need to make, please, after Roland? Thank you.
Mm-hmm.
Roland?
He's disappeared.
Good afternoon, everyone. Can you hear me okay?
Mm-hmm.
I was planning just to listen today, but I've got to respond based on what I heard, especially what Tanika said. And my mic tripped out at one point, but I think my audio tripped out at one point. I think Garrick said that as well. Correct. I stand corrected if you did not say that, Garrick. The Labour Party has not been in power long. As far as myself, that I've got a good understanding of what has been happening over the past years, decades, and especially the campaign that has been going on. I think the Labour Party has been in power a very, very, very long time. The Labour Party does not need a run-up to what has been happening. They know clearly exactly what has been happening due to the campaigns that have been going on by various individuals, myself and others. That's my assumption that they do know what's happening, has been happening. If they do not know what is happening, that means they do not care. And if they know what has been happening, they do not need a starter gun for them to get going. They have been in power a very long time. This narrative that government moves slowly, I do not believe in it. Government moves very, very fast. So I'm not going to contribute to this narrative that the party has not been in power for a very long time. I find it insulting for the Labour Party to give that impression in any way, shape, or form, or to use that as an excuse. What needs to happen is for them to engage with those individuals that understand what has been happening in terms of the scheme, the failures, etc., etc. What the Labour Party should not do is engage with the favorite community leaders or the favorite community pacifists, etc., etc., because I have got reason to believe that's what's going to happen. They will engage with those that are not willing to insult them, tell them exactly how they have been involved over the years, in what has been done to the Windrush generation, etc., etc. They need to engage with individuals that understand clearly what has been happening and is willing to embarrass them anywhere, in any way, shape, or form, wherever, because what the Windrush generation and their descendants experience, as per the report, and as a number of us has been saying, UN, Egbert, etc., etc., it was done to the Windrush generation. It did not happen to them. It was deliberate and calculated. And we that have been saying it, Egbert, myself, etc., etc., that report vindicated us last week. Thank you very much.
Thank you, Roland.
Before you go, one final thing. Yeah, if I can. Good to hear from you, Roland. Good to hear from you. I want to summarize all this, what Roland just said there. That report showed, yeah, it's historic, yes, but in recent times, at a period of time, yeah, what was done was deliberate, and it was take away the economic rug, the social rug, the health rug, the benefit rug, everything. Pull the rug out from under their very existence and see what they will do. And if that happens, I've said to Roland already, it was temporary and the platform already in place for this to be repeated. And if you guys don't wake up, it's going to happen. And it's going to happen to British citizens. British. Okay? That's it.
It's already happened to British citizens, Egbert.
Tanika.
The descendants are British citizens. You mean white British? Is that what you meant?
Well, Amazon tree frog. It's going to happen to Black British people in this country. What you're talking about is racism. I've been in education in this country. I've seen Black kids excluded, and I fought for them. Yeah, I've been in employment. I've seen the white Commonwealth come here, and the Blacks get kicked out. I've seen the whole lot. Yeah, and what I'm saying is, what happened with the Windrush? It was the pulling out of essentially a rug from under the Black community, with the hope that you would get so fed up and so peed off, you would go back to Africa or wherever else you came from. And that started at a particular period of time. And I've used the word entrapment before. I think the Tory party passed legislation to lay a trap for the Labour government that was coming in, just make sure they act on it because of their philosophy and their ideology, yeah, and see what will happen. Everyone just kept quiet and watched. Well, and if you look at the Hong Kong legislation as a comparison, look at that Hong Kong piece of legislation as a comparison, trust me, and you will say, you know what, there was a point in that argument. But I'm not going to debate anymore on it.
Thank you, Egbert. I'm not sure if Roland was just insinuating that I am being passive, or
I don't think he was, Tanique. What I'm saying,
no, Egbert
was to stand up and say, "Want all blacks out of this country tomorrow." Yeah,
Egbert, can I finish my statement, please? Thank you. As I was saying, Roland, I'm not sure if you were stating that I'm being passive or I am giving the current incumbent government leeway, saying, well, okay, they need more time. I do believe they need more time to get their ducks in a row, personally. I don't think that they've met a well-structured system from what the Tories left. But I do agree with what you said, i.e., that they can work fast, as we've seen during COVID and other pieces of legislation being passed really fast and corrective action taken for certain things. Look at the post office scandal. So, I agree with that point. That's just my personal view. I do not speak for the Labour government or anybody else but myself. And Liverpool advocates for Windrush with Garrick. But having said that, be realistic, but at the same time still call for the changes that we want to see. Other than that, I concur with what you said, Roland. Hence, I've been in this space for a number of years, as who most of us on this call and people who do know me, including you, Roland. I do think you know me better than that. But nonetheless, I felt for the benefit of the recording and this being on, in the public domain, I needed to say that. Again, thank you all for your contributions. It is an emotive subject. We are all here because we want the same thing. We're fighting for the same thing. We've worked together. We fight together. We're here to support each other, even when we're challenging each other as we have today a little, which is good. It's healthy. That's what it should be. Have the difficult conversations. As my partner will say, get comfortable being uncomfortable. And if we can do that, maybe we'll get things right. Maybe we'll help those in power to get things right and use every opportunity that we get to kind of hold their feet to the fire, as you plan to on the 16th. Garrick, I don't think Roland actually said what's happening on the 16th, but maybe you can instead.
Yeah, I'll just mention that as the final comment. So, Tanika,
yeah.
are we going to say anything for Liverpool? What's
No,
on?
because that's
Okay, that's fine. Keep that
so
as
we'll
is.
do it on the next.
The next
I
one.
figured yes. So
Yeah,
no.
that's okay. Yeah. So for the benefit of our
Yeah.
audience today, just to say on the 16th of October, Wednesday the 16th, we're in Parliament for our Windrush rally. It's a round table format, and we have a number of organizations coming in person, and we'll be given a few minutes to actually make their point. And the issue is, the Windrush manifesto. What next? We've got the written manifesto. We need to know now how we move that forward. And then the second conversation is about this report that we've been talking about, because we want to push for changes. We have a sponsor from the Labour Party sponsoring the event, and we have written to the Home Secretary and the Home Office to ask for a minister to attend the event. So we'll wait to see if a minister will attend. It starts at 1700 at 5 o'clock through to 1900 approximately. It's out on Eventbrite, so you can find it on Eventbrite, and encourage people to attend. Committee room number 11, and the capacity there is about 60 people in the room. So just share that information, please, with other people, particularly those who are in London. That's easier to attend because of the location. Roland?
Thank you for that, Garrick.
Yeah. Can I just elaborate?
Before you do, Roland, just 1 minute for me, please. We are now 5 minutes after 5. We're 5 minutes over time. So if anybody needs to go, thank you again for attending today and hope you've learned a lot. We will see you on the first Sunday of every month. So that will be the first Sunday of November. Roland, thank you.
Okay, just bring a bit of clarity or elaborate. The rally in the House of Commons will be leading on from the promises that the Prime Minister made when he was campaigning. The manifesto is already launched, it's out there in the community. And also the other recommendation that Justice for Windrush Generation were putting forward, that to make the scheme, as far as we're concerned, closer to being fit for purpose. And the working title of the event is Make the Windrush Scheme Fit for Purpose. So that's where we'll be at, and we'll be discussing some of the failings within the scheme that were specifically and deliberately designed into the scheme, i.e. page 49 for those that have been locked out of the UK, pension, and other failings within the scheme. So in brief, make the scheme fit for purpose. Promise was made prior to the election. Engage with the likes of us that knows exactly what we're talking about and the failures, etc., failings within the scheme. And let's see what this reset is that the Prime Minister mentioned. So what we're saying is action time. You should know exactly what needs to be done, somewhat, the Prime Minister and other decision makers, and engage with us, and we will take you through, walk you through the failures and eliminate the excuses that you, the government, and other decision makers may have, because this may be an opportunity, and we don't want to come around here again and have a year from now or whenever have the same problem that we're having. We need to have the right people at the table discussing the failings in order that we can get a scheme that is closer to being fit for purpose. And we're not going to be asking for any more than we deserve. That's it. Thank you.
Thank you for that, Roland. And by way of announcement, we are now up and running with Liverpool John Moore University, the Pro Bono Clinic. They offer several clinics, including family, civil, commercial, housing, criminal drop-in centers will be run. Appointments start from the 14th of October. So if anybody wants to see us in person or drop by the clinic, they have lawyers who supervise. It's a student-led clinic. And they're solicitors who supervise the students. Liverpool Advocates for Windrush, we have partnered with Liverpool John Moore University's Pro Bono Clinic collaboratively to offer Windrush support, and we'll be running a clinic there. I have already started, so if anybody wishes to have an in-person appointment either through the clinic or with us, please feel free. That means, in short, we have more support. We have law firms coming forward who've agreed that, well, one, they want to work with us, want to help us, want to be involved. So we are expanding quite rapidly. Praise be to God. Thanks God. So if you need support, need advice, we're trying to get more immigration support. So GAMU out in Manchester, people may know Nicola Burgess, who won the JR. She's agreed to work with us, our partner, to support the clinic. Lee Day, the Liverpool branch. Jackie is, I know a lot of people know Jackie Lee Day. Normally they're synonymous when Lee Day is mentioned. Jackie's in London. So they have also agreed to support us if we have any queries, complex scenarios or cases, be it nationality, which, for example, I'm not the expert on. We have lawyers who can. We have other local firms, for example, the Hilbert campaign, which the Prime Minister has agreed that he will pass a law next April 2025. So one of the things I've put forward to those who started the Hilbert campaign, the Hilbert law, which means or basically says that public office holders have a duty of candor. I've inquired, why hasn't there been a Windrush inquiry? Why can't the Windrush scandal come under that and be afforded the same rights? So that's something we're working on at Liverpool Advocates for Windrush in collaboration with Liverpool John Moore University's Pro Bono Clinic. So there's lots of things on the horizon, which is what Gareth was alluding to some of, to share today. We're not going to until we have things in concrete or in writing. But we are on the same page as everyone here. We are fighting for change, lasting positive change, tangible change. So let's see where we get to. Again, thank you everyone for your contributions, participation. If there's nothing else, Garrick, Roland, is that a legacy hand or you want to come back in?
Yeah.
Okay, I just took it down, so I
Yeah,
wasn't
that's
sure.
fine. Yeah. So, thank you all for attending. Have a good afternoon. Enjoy the rest of the day. And this posting will be out on YouTube for those who have missed the session to replay it. Just visit our website, liverpooladvocatesforwindrush.org. And also our Zoom ID has been updated as well.
Yes, we will send out the link every week. Sorry, every week. I'm thinking we're doing bi-weekly.
Monthly. Mm-hmm.
Yes, every month now. And apologies for those who have tried and couldn't get in. I have had messages from people sending their apologies as a result. My apologies as well. I was under the impression it will just continue over because it's the same account and everything else. It doesn't work like that, I was told after the fact. So my apologies once again. But thank you everyone for a really, really engaging conversation. I enjoyed it. I learned a lot. So thank you, and I hope you did too. And we'll see you in the next session, the first Sunday in November.
Great.
Have a great week.
Thank you all. Okay.